Good morning. The next case to come before the court is Andrea Riffle versus Physician Surgeon Ambulance Service et al. Both sides ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
Each side will have 15 minutes to present their arguments. The appellant may reserve up to 5. We're ready to proceed.
Thank you, Your Honor. Good morning. Just happy St. Patrick's Day. May it please the court, my name is Christopher Reese. I represent the appellants in this case, the City of Akron, Lieutenant Todd Kelly, and Stacy Fravada. Lieutenant Kelly and Stacy Fravada, you probably pieced together, are 2 EMTs employed by the City of Akron. I'd like to reserve maybe 3 minutes for rebuttal. 3 minutes for rebuttal. I'd like to try to cover in the short period of time this morning, I broke it down into maybe 4 subjects, or 4 topics. And the first I'd like to touch on is precedent, this idea of precedent. You know, since way back in my law school days, you know, people stress the value of precedent in a case and search for precedent and argue precedent to a court. And very few times, I think, has a case landed on my desk where it appeared to me, at least when I began to argue the case or put together a brief, that precedent seemed to be overwhelmingly, which might be a strong word, but at least in the city's favor and in the appellant's favor in this case. The city and the appellants, the EMTs in this case, argued to the trial court 8 cases that dealt with the willful or wanton issue. And all 8 cases found no willful or wanton conduct. On the other hand, well, before the case that the appellees cited, let me address that. Well, one of the frustrating points of this case was that when the city or the appellants asserted these 8 cases and argued for their application and provided little summaries in their brief of them, neither the appellees in the court below nor on appeal distinguished those cases. You know, they all seemed to lay out the facts and then have a finding of no willful or wanton conduct, but there was no effort on either the appellee's part or the trial court's part, in its opinion, to distinguish those cases. I'm not going to stand here today, obviously, and rehash those 8 cases. I think one is worth noting, though, and it's the case called Branham, B-R-A-N-N-A-N. And the reason I stress that case is for 2 reasons. One, it was just decided last fall, and it was decided after the trial court issued its decision last summer, and oddly enough, it came out during the briefing of this particular case. So it found its way into our reply brief, and it didn't find its way into the, I guess what you call the merit brief, or the case in brief, or the main brief. So I didn't want the Brandon case to fall by the wayside merely because it found its way into the reply brief. But the Brandon case and those facts, when it came out last fall, I read it and I'm like, wow, these cases seem to be absolutely analogous, or at least fairly analogous to the facts of our case. At the risk of rehashing those cases, they're dispatched to an expected mother's call, a labor call. They arrived 45 minutes later after the call, even though the distance was only 3 miles, and the infant was born before they arrived. The paramedics began treating the newborn infant, and they called for private ambulance backup similar to our case. The infant's condition worsened. They waited 30 to 35 minutes for the private ambulance, and then the paramedics decided not to even transport the infant. Why? Because protocol said you can't put the mother and the infant in the same truck. So they waited for this private ambulance to show up. Finally, the private ambulance shows up, and those are pretty much the facts of the case. And even under those facts, the Branham court found that while they questioned the protocol and they questioned the decision in hindsight, that these choices may appear to be negligent, or in fact may have even been negligent, we find the request for backup and their decisions made as evidence of some degree of care. Therefore, we decline to find willful or wanton conduct. You know, they're not absolutely analogous to our facts, but it's the same kind of thing. You know, the paramedics made certain decisions, and what the Brandon court found significant was there wasn't a complete lack of care. There was some degree of care.
Well, what was the degree of care here to the fetus?
To the mother or the fetus?
The fetus.
Which skips ahead to one of the trial court's rulings, which was the trial court found that there was a question of willful or wanton behavior because of the failure to treat the unborn fetus. In Lieutenant Todd Kelly's deposition, you'll find testimony that Akron paramedics do not treat the unborn fetus. There's not, in this case, they've been searching for a separate incident report or a run report for the unborn fetus. Lieutenant Kelly testified that they show up at these labor calls, they treat the mother, they assess the mother, and by doing that, they assess the condition of the fetus, the unborn fetus. They don't have the equipment, they don't have the training, they're not OBGYNs, they're not emergency room OBGYNs, so that's a long answer to your short question, Judge, which is they can't be held to be wolf or wanton for not doing something that they don't do. They don't.
Maybe it's greater than the individual paramedics. Well, you're saying, your argument is they can't be held willful and wanton for something that the city has instructed them not to do.
Well, not instructed them not to do, but it's not protocol, it's not training. I mean,
Well,
they just simply don't do it.
Somebody had to make that decision, though.
On a larger level, I guess.
That's what I'm saying,
Yeah,
greater
right,
than
right.
the paramedic.
I mean, it would be, what would happen in that situation, Judge, I guess from a practical standpoint, this is jumping outside the record, is you're delaying transporting the mother and the infant to the hospital so a doctor can treat them. If you spent 35, 40, 60 more minutes treating an unborn infant at the scene, you're delaying the transport. You need to get these people. The object of EMTs in this situation isn't necessarily to treat, it's to assess and transport. They need to get a mother, an expectant mother, and an unborn fetus to people who do treat them, which is the hospital. That's why this is not a failure to treat case, and that's why we're arguing at the trial court. If the trial court, what I read in the trial court's decision was, I believe they found that it was, that's just simply not the case.
But as part of the assessment, I'm sorry, I can't remember the one paramedic's name right now.
The female is Frabata.
The female. She did testify in her deposition that she had considered the report that there was serious blood, there was, that the mother was bleeding, and that was the report that was called in.
That was correct. That's the dispatch. They were dispatched to a call for serious bleeding.
But isn't that part of assessment?
Here's how the assessment occurs in these situations. They're dispatched to a scene, and the dispatcher's notes are with them. The paramedic's duties in these scenes, and this was educational for me, is to show up at a scene and by either a physical examination of the patient and through a discourse, a Q&A, and things of that nature, they either confirm the information that they have in the dispatch or they dispel it. Stacy Frabata gave me an example of a lot of people call and say, I'm having serious heart pains. Most people claim that what they're having is a serious condition. You don't call 911 and say, I'm having mild chest pains or dull chest pains. Most of the calls that they're dispatched on are tagged serious because the people want one of two things. They want you to get there fast, and they're also calling 911, and they believe it's a serious call. So the paramedics show up, whether it be the scene of my hypothetical chest pains or this scene of an expectant mother. The EMTs show up and they try through an assessment to either confirm or dispel and then make a transport decision. And that's exactly what happened here. When the paramedics showed up, there was no serious bleeding. Had there been serious bleeding before, Mrs. Riffle's deposition at page 35 or 38 does contain a line that she recalls that she made reference to, that she had had some bleeding earlier and before they arrived. But I can tell you that Mrs. Riffle's deposition testimony at page 38 or 35 and the testimony of the two paramedics are there was no bleeding after the paramedics arrived. Whether they confirmed or dispelled the notion that there had been serious bleeding, it's not a material fact here.
Why is that not material?
Because they assessed the situation that presented them and they made a decision to transport. They would have made the same decision.
But they may have made a decision to present this as an emergent situation rather than just a first-time delivery, which would have had an impact on whether they even called a private ambulance,
Right.
number one. Number two, how it would have proceeded once they got to the emergency room.
Well, let me take those separately, Judge. These things don't happen logistically that they arrive and they decide this is just the first time typical delivery, let's call AMR. What happens here is AMR is called immediately, and AMR is on the scene of these things because AMR wants the business. And one of two things happens. They either go with AMR or the Akron Fire Department says this is a code 3, you can go on, and they leave. So there's a misunderstanding in this case that there was some sort of decision made to go with AMR and they had to wait on AMR and AMR got there later. AMR was on the scene. Whether she was going to be transported in the fire department's rig or in AMR's truck, they were both in the driveway. That's the testimony.
But there were two separate assessments, again.
AMR did assess her when she was there, and there's testimony in the record. Mike Castle is the AMR paramedic, and his testimony at page 32 is, Castle did not believe she was in any distress and there was no active bleeding at the time of AMR's attention. At the same page, Castle's notes that Andrea Riffle was a normal delivery with no complications. So even after, I don't want to use the term handed off, but even after AMR arrived and there was a decision made to go with code 2 instead of code 3, AMR did their own assessment, and here's what can happen in that situation. AMR can say, whoa, this is a code 3, you take her. But that didn't happen. AMR agreed that, or I guess, what's the word I want to say, concurred with the Akron paramedics' decision that this was in fact a code 2, or appeared to be a code 2, and proceeded in that manner and transported her to the hospital.
Do we know from the record whether AMR also had a written document at the time they made their assessment that the dispatcher, where the dispatcher had indicated serious bleeding? And as I understood from the briefs, it was in all caps.
The report of serious bleeding. I don't want to misrepresent the record, Judge, but I don't think that I recall that AMR, that AFD passed to AMR the dispatch notes that they had. I think what they probably did was show up, and I can only surmise that AMR said, what do you have on your hands? And Frabata tells her what she has on, tells this paramedic what he has on his hands, and then they do their own assessment. I mean, there's a practical aspect to this. They don't waive the serious bleeding dispatch notes. If it was, I gotta believe, and Stacy Frabata's testimony is that had she shown up and confirmed serious bleeding, had she seen it, it would have been a code 3. Had she seen it, or had that discussion or that discourse occurred between Mrs. Riffle and Stacy?
Well, so are you suggesting it had to been bleeding on the spot when they arrived there, or prior to them getting there? Is there a difference between the two?
Well, I guess if you showed up and there was bleeding, I mean, I think that would probably present a more acute situation than take the chest pain situation. You show up and the guy says, I'm just kind of having a digestion or something. Well, the fact that he complained of serious chest pains, you're now making a decision on what you discovered when you came to the scene and did your assessment of it. So I think that is my answer to the question.
But even in that scenario, you would still look at the historical data that you have and consider at least the fact that he may be feeling better now, but at some point he called 911, just like you said, because you don't call 911 usually unless you're in severe distress. So obviously at one point he was having chest pain, unless you just think he's lying.
Going back to the question whether that fact is material or not, here's my answer to that. This is all being examined in a willful or wanton context. If the case before us was that the paramedics showed up and there was a prior complaint of serious bleeding, and they showed up and they did an assessment, but let's say that the allegation is it wasn't a thorough assessment and they didn't inquire into the serious bleeding. The cases that find willful or wanton conduct, that would arguably, I'll concede for the moment, that would arguably have some traction as a negligence claim. But willful or wanton is a negligence plus standard. Had the paramedics shown up and done an assessment, but not inquired into the serious bleeding complaint, packed up their belongings, packed up their truck, and said, "Good luck, Mrs. Riffle. I hope your husband can take you to the hospital," which is a code 1. That case, the failure to transport, a failure to thoroughly assess, plus a failure to transport could possibly create a willful or wanton issue. And that's the Huber case, that's the Weber case, which is the only case the appellees cite in support of this. They show up at Weber's house, the guy's having a stroke.
Counsel, I don't mean to interrupt, but
Sure.
you want to say it anytime. Okay?
Oh, yeah, the one
I was
point.
trying to discreetly say,
Sure.
yeah, trying to save your time. Okay, do you want to proceed, or do you want to?
Well, I'll just proceed.
Okay.
That's fine. And the Weber case is, in brief, that's the case that the appellees use. Mr. Weber's having a stroke. The paramedics show up. "I'm having a stroke, and I'm blurred vision, I'm dizzy." They're like, you're having a panic attack. They assessed it, they didn't thoroughly assess it. What they did in Weber was, they packed up their belongings and drove away. Mr. Weber goes to bed, gets up the next day, worse, goes to the hospital, he had a stroke. The reason Weber found a question of fact, the only case that I'm aware of that found a question of fact, was because there was a questionable assessment and a failure to transport. Those facts are absent in our case. Mrs. Riffle was transported to the hospital. Froboda and Kelly did not pack up their equipment and leave the scene and leave Mrs. Riffle to fend for herself. AMR transported her. You need a failure to transport to find willful or wanton conduct under the law I'm reading.
Okay.
Look,
You're out of time,
Oh.
I'm sorry. Sorry about that, thank you.
thank you. Obviously, I'm requesting that the court reverse the trial court and enter summary judgment in favor of the appellants in the case. Thank you.
Thank you. You may proceed.
Good morning, may it please the court. My name is Rebecca Cull, and I'm here on behalf of the Riffles, Dan and Andrea, in the estate of Tenley Jane Riffle. There are two things.
Your last name is Cole?
Cull, C-U-L-L. There are two things for this court to keep in mind as it considers the appeal from the trial court. The first is that this is an appeal from a denial of summary judgment, which means that in considering all of the facts that have been presented to this court, any disputed facts have to be construed most strongly in favor of the appellee. So in this case, as Mr. Reese stated, there's evidence in the record that the paramedics were aware of a situation involving serious bleeding. They had subjective knowledge through the 911 incident report, and there's testimony from Andrea Riffle's deposition that she personally informed the paramedics about the serious bleeding she'd experienced when they arrived on the scene. Construing those facts most strongly in favor of the non-moving party, the Riffles in this case, there's no question that the paramedics had knowledge of a history of serious bleeding when they arrived on the scene at the Riffles house that night. The other thing that's important for this court to keep in mind as it conducts its review is that the two issues before it, the character of misconduct, whether it rises to the level of willful or wanton, and also this issue of causation, whether there's sufficient evidence on causation to move forward, are both quintessential jury questions. In Anderson versus Massillon, the 5th District Court of Appeals, considering a similar willful or wanton misconduct case involving sovereign immunity, pointed out that Ohio courts have consistently held that the character of this kind of conduct is a jury question. And similarly, in a 1st District case...
Well, are you suggesting that all you have to do is allege willful and wanton and you go to a jury?
No, Your Honor. Simply by alleging willful or wanton, you wouldn't get through to a jury. But in this case, the discovery that's been conducted has provided deposition testimony and expert affidavit testimony to support the fact that there was willful or wanton misconduct.
But you're not really alleging willful misconduct, right?
We are, Your Honor.
I thought you were more going with a wanton.
There are both willful and wanton instances of misconduct here.
Because I think deposition testimony demonstrates that your client said that they didn't think that anybody intended to harm them.
It's true. Ms. Riffle did testify that no one intended to harm her. The question when considering willful misconduct, though, is an intentional deviation for a clear duty or rule, not necessarily an intent to harm, but an intent not to fulfill a duty with an understanding of the serious consequences that would result.
Well, go ahead. I'm sorry. I'm asking too many questions. Go ahead. I'll let you talk and maybe I can follow with them.
There are a few examples of instances where particularly paramedic Froboda intentionally ignored clear duties that she had. First of all, everyone agrees, EMT Kelly, EMT Verboda, the experts here, agree that there is a duty to obtain a complete obstetric history when responding to a patient in her 3rd trimester. Verboda and Kelly both agree that obtaining a complete obstetric history includes obtaining a description of any discharge that the patient has had. If the paramedics suspect that a patient's water has broken, they should obtain information about what color the discharge was, the volume of the discharge, whether it had any odor, in order to make sure that there's not a serious bleeding incident. In this case, if Ms. Verboda had in fact conducted a complete obstetric history when arriving on the scene, she would have learned firsthand from Andrea Riffle that she had suffered a substantial and severe bleeding episode prior to their arrival.
But they did know that because she told them, right?
That's also right. So too, Andrea told her specifically when she arrived, and if she had continued and conducted the complete history, she would have had that information there also.
Well, but how does that go to willful or wanton failure to complete a duty in the respect that you're saying they were willful and wanton because they didn't question her in order to obtain the serious bleeding incident information, but she gave it to them, so how does that really matter then? Because just because they didn't necessarily ask her, she told them, so they did know the information.
The city has
And the whole
taken...
point of that is to obtain the information.
Right. The city has taken the position that Andrea didn't tell them.
Mhm.
So if you accept as true the city's argument that Andrea did not expressly tell them, they were under this duty
But
to
we don't
collect the
accept that as
information.
true, we accept what you're saying is true.
That's true, yes.
So I'm just not understanding completely, I guess.
Well, even if the duty to collect an obstetrical history does not rise to an intentional deviation from a duty, there arises a duty to transport a 3rd trimester patient with a history of serious bleeding emergently to the hospital. That's a duty that arises by the Akron City Paramedic Protocol, and that expert testimony is supported as appropriate under the circumstances. So with the knowledge, either from the run report or directly from Andrea, that they were dealing with a patient in her 3rd trimester of pregnancy with a history of serious bleeding, Kelly and Verboda were under a duty to provide oxygen, to start a saline drip, and to transport emergently, which is different from transporting immediately, which is what the city has argued here. Which I also have a little bit of a problem with the characterization of her transport as immediately. AMR was not on the scene at the same time as the city. There was some overlap, but AMR was later. As the court pointed out, AMR conducted a separate assessment, which further delayed things. Even in the city's brief, they acknowledged there was a delay of at least 15 minutes in leaving the Riffle household to go to the hospital, which I don't think it can be fairly characterized as immediately. Even that is far different from transporting emergently with lights and sirens and notice ahead to the hospital to expect an obstetric patient prepared to deliver on an emergency C-section basis. According to Dr. Crawford, one of our experts, the failure to transport emergently cost 45 to 60 minutes and the time that Tenley could have been delivered. And in the opinion of Dr. Crawford, that delay ultimately caused her death. So in terms of an intentional deviation from duty, the city's own protocol requires a certain series of steps to be taken after the paramedics are aware that they're dealing with a 3rd trimester patient with a history of serious bleeding. And rather than follow that protocol, Verboda and Kelly walked on the scene, and according to Ms. Verboda's own testimony, she decided to ignore the report of serious bleeding, either from the 911 report or from Andrea herself. But she intentionally chose to ignore the information that she had and move forward in a different direction instead of following the duty and the protocol that she had to follow. As the court pointed out, there's also a pretty severe instance of wanton misconduct in this case, the failure to exercise any care. And as the court addressed earlier, particularly with regard to the treatment of Tenley, of the fetus in this case. Again, I think the choice not to, There is an issue of fact in this case about whether there's a separate duty of care owed to an unborn child. Ms. Froboda testified that there's not a separate duty of care. Mr. Kelly testified that there is. Plaintiff's experts have stated that there is a separate duty of care owed to an unborn child in this case. There is no dispute, though, that no care was provided to the infant. The city has argued that the EMTs were not trained, that it's not part of their policies, that it's not part of their procedures. It should be. The standard of care is that there should be some care, assessment, treatment available to a fetus, available to an unborn child in this sort of situation. It could be something as simple as asking the mother the last time she felt fetal movement. It could be as simple as placing hands on the mother's uterus to detect fetal movement that way. Even simple, very low-tech assessment options like that were not taken in this situation. So in this case, it's very clear that there was a complete absence of care in regard to the treatment provided to Chenley Jane. The other element in these two standards, both the intentional deviation from a clear duty under the willful standard and also the failure to exercise any care under the wanton standard, require a recognition of a great possibility of serious harm. And I don't think there's any dispute about that. Froboda and Kelly and the experts in this case have acknowledged that serious bleeding in a third trimester patient is an emergency that poses a serious risk to the mother and to the child, and potentially death to the child if it's not treated as an emergency. So there's a recognition on behalf of all the parties here, subjectively and objectively, that serious bleeding under these circumstances poses a great probability of serious harm. I'd also like to address briefly the causation argument that was brought up by the city in its briefing. I think this is a pretty classic issue of the credibility of experts in determining the cause of Chenley's death. On the plaintiff's side, we have experts who have opined that the cause of death was placental abruption. One of these experts is Dr. Monty, who was the doctor who was present at Chenley's birth. He performed the C-section and was able to observe the placenta, the umbilical cord, the other contents of the uterus, and make an informed judgment about the cause of death at that time. We also had the opinion of Dr. Crawford, a perinatologist, to support that opinion as well. The city has presented the testimony of an expert who has opined that the cause of death was vasa previa, and that vasa previa is uniformly fatal when it occurs outside the hospital. Therefore, the paramedics could not have prevented this death, and therefore there's no causation based on the delay. However, Dr. Crawford has submitted an affidavit in which she says that more likely than not, a child can survive vasa previa if the baby receives timely treatment. So that vasa previa is not uniformly fatal, even if the jury were to believe that that was ultimately the cause of death, that with timely treatment, it could have been prevented. Finally, I'd like to spend some time to address the contention that we have not responded to the cases brought up by the city that set this precedent that willful or wanton misconduct doesn't occur under these circumstances. We did distinguish this case from those cases in our memorandum in opposition to the motion for summary judgment. These cases fall in a few different kinds of categories. In Denham and Johnson, paramedics showed up on scene and attempted to provide care to a patient, but were unable to provide care because the patient refused. That's not the situation we have here. Andrea did not refuse care. She didn't walk away from care. She didn't resist care. In Donlin and Mitchell and Bush, the paramedics were unable to provide care because they lacked appropriate medical equipment. There's no contention here that different medical equipment or better medical equipment would have made a difference in the treatment. And then in Mitchell and in Blair and in Brennan, the paramedics who arrived diligently attempted to provide the best care possible and simply fell short of a best care standard. I disagree that Brennan is completely on all fours with this case. In that case, as counsel said, when the paramedics showed up, the child had been born, and required immediate medical assistance. While the paramedics were waiting for a separate truck to show up, they attempted CPR, they provided blow-by oxygen, they tried to keep the child warm to prevent the child's condition from deteriorating. There's no similar kind of course of treatment here. As in Weber, where the paramedics showed up, took vital signs, made a decision about transport, and left. Here, the paramedics showed up, took vital signs, made a decision about transport, and left. And in both of those cases, the decision about transport was the wrong decision. In Weber, there should have been a transport to the hospital. In this case, there should have been a transport to the hospital emergently. It says so in the Acting City paramedic protocols. It's the standard of care as opined by Dr. Olinger. And it's what both Kelly and Farbata acknowledged they should have done with a report of serious bleeding for a patient in her third trimester. So under these facts and circumstances, with the record as clear as it is in favor of the non-moving party, we respectfully request that this court affirm the decision of the trial court. And if there are no further questions, I'll sit down.
I don't believe so. Thank you.
Thank you.
For your presentation. Thank you both for your arguments to the court today. The court will take the matter under advisement. A written opinion will be sent to both sides, and it will also be reported on the Supreme Court website and our own website. Thank you very much.
Thank you.
Thank you.